Welcome to the Pennsylvania Case Law Update While You Drive podcast. You give us less than 20 minutes per week, we will make sure you never miss changes in the law. This week's episode is brought to you by the McShane Firm. For nearly 20 years, the attorneys of the McShane Firm have been trusted by our neighbors and our friends to represent them in DUI and criminal law cases.
Welcome to Episode 6 of the Pennsylvania Case Law Update While You Drive podcast. I'm your host, Katie McShane, and today we cover cases decided between July 22nd, 2020 and July 28th, 2020. Again, only majority opinions will be discussed in today's podcast. Today, we begin with criminal law. In the case of Commonwealth v. Johnson, the court addressed another Post-Conviction Relief Act case where the defendant filed a PCRA petition listing multiple docket numbers on a single petition. In this case, the court found that an individual petition was filed in each case, despite the petition not containing a single docket number. The court was able to ascertain that they were filed independently based on the location and time on the clerk of court's timestamp. As the PCRA petition was properly filed, the court addressed the merits of the case. In this case, the defendant was charged with and convicted of homicide following a robbery with 3 other co-defendants. During the robbery, the victim, who is the defendant's grandmother, had a pillow placed over her head and face while money and property was stolen from her home. The victim suffered a heart attack during the event and died approximately 2 months later. The cause of death was ruled to be due to the heart attack that occurred during the robbery. The defendant claimed ineffective assistance of counsel because her lawyer failed to call and present testimony as to the cause of death. At the PCRA hearing, the defendant presented medical testimony claiming that the death was the result of lung disease and not a direct result of the robbery. The PCRA court considered this testimony in addition to the testimony of 2 other medical doctors that testified at the co-defendant's trial. In making its finding as to whether the verdict would have remained guilty, the court considered the testimony and verdict from the co-defendant's trial, which the Superior Court found to be improper. The PCRA court should have considered whether or not the verdict in the defendant's trial would have been different had her attorney presented the appropriate medical evidence. The case is remanded to the PCRA court to make the appropriate prejudice determination when weighing the evidence with the record in the defendant's trial, not the co-defendant's. In the case of Commonwealth v. Leclair, the defendant was charged with first-degree murder and other crimes after he took his wife to the middle of Lake Erie in a boat, shot her in the head, and then dumped her body overboard. He then reported to the Coast Guard that she had fallen overboard, for which the Coast Guard undertook a search and rescue operation. Following a conviction for first-degree murder, the defendant was sentenced to life in prison and ordered to pay restitution to the U.S. Coast Guard for costs incurred as a result of the defendant's false reports. On appeal, the defendant argued some evidentiary questions, though the primary focus of the case was whether or not the Coast Guard was considered a victim for purposes of restitution. The Superior Court held that under the Crime Victims Act and prior case law, only an individual and not a government agency can be a direct victim, and as such, the Coast Guard is not entitled to restitution. In the case of Commonwealth v. Hajdarevic, the defendant was arrested for suspicion of driving under the influence. At the trial, the arresting officer testified as to the circumstances surrounding the traffic stop and the performance on the field sobriety tests. He then testified that the defendant was arrested and transported to Chambersburg Hospital for a legal blood draw. The officer did not testify as to the time of the blood draw. The Commonwealth also presented the testimony of the lab technician who tested the blood. In addition to testifying to the results, the lab tech testified as to the time of the blood draw. The lab tech was not present at the blood draw and only knew of the time of the draw because it was written on the sample tube. The defendant was convicted at trial and appealed. The issue raised on appeal is whether the defendant's right to confrontation was violated when the lab technician was allowed to testify to the time of the blood draw, or more specifically, if the time of the blood draw is a testimonial statement that cannot be entered into evidence via another's representation on a chain of custody document. The court found that testimony related to the time of blood draw is a testimonial statement and is required to prove an element of the offense beyond a reasonable doubt. As such, having anyone other than a witness who personally observed the blood draw testify as to the time of the draw is a violation of the defendant's right to confrontation. The court overturned the opinion of the trial court, vacated the judgment of sentence, and remanded the case for a new trial. The next case is a family law matter. In the case of P.L. versus the Department of Human Services, P.L., mother, is appealing an indicated report of child abuse. In this case, mother hit child on the head with a broomstick, causing a 2-centimeter laceration. Mother indicated that child was jumping on the couch. Mother repeatedly asked the child to stop jumping on the couch, and when he did not listen, she used the broom to tap his shoulder to get him to stop jumping on the couch. As a general rule, actions by parents on or against their children for the purposes of supervision, control, and discipline, as long as the parent uses reasonable force, are not considered child abuse. At issue before the court in this case is whether reasonable force was used, and in doing so must consider whether the actions of the mother were criminally negligent. Criminally negligent means disregarding a substantial and unjustifiable risk or deviating from a standard of care that a reasonable person would observe in this situation. The action of the parent must be considered, not the result. The court found that when considering the totality of the circumstances, the mother's actions were reasonable and that she did not act with criminal negligence. The indicated report of child abuse is overturned and the matter ordered to be expunged. In the medical malpractice case of Talmadge versus Ervin, the estate for the decedent sued the doctor and the pharmacy that provided medication to the decedent on the grounds that the combination of prescribed medications caused QT syndrome, which then caused the decedent's death. Prior to trial, the court granted a motion in limine excluding a pill count document on the basis that the document was hearsay and was not properly authenticated. Following the jury trial, judgment was entered in favor of the defendants. On appeal, the plaintiff alleged that the court erred by granting the motion in limine because the document was testified to at the deposition and the objection was not properly preserved to raise in a motion in limine. There was a single objection made when the testifying expert referred to the pill count document. However, during subsequent questioning, the document was referenced several times and admitted as an exhibit by the plaintiff. There were no objections raised at that time. On appeal, the court found that the trial court did in fact err by granting the motion in limine and excluding the pill count document because they had waived the objection to pill count document coming in, and it should have been admitted at trial. While this issue is dispositive, the court also addressed the qualifications of the plaintiff's expert witness. The court found that the witness had the appropriate qualifications, skill, and knowledge to testify as an expert. We'll be right back after a brief note from our sponsors.
This segment of Pennsylvania Case Law While You Drive podcast is sponsored by the McShane Firm. The McShane Firm is Pennsylvania's largest and best DUI and criminal law firm. Their mission is simple: make sure the presumed to be innocent remain innocent.
Welcome back to the second half of our podcast. In a property law case, Metal Green Incorporated versus the City of Philadelphia et al., at issue is a requested variance for a building located in Philadelphia. The building is a 23,000 square foot industrial building and had been vacant for quite some time. In 2016, a local nonprofit initiated an action against the owners claiming the building was blighted and abandoned. In response, the owners were allowed to pursue redevelopment of the property. The property was in a two-family attached dwelling zoning district, meaning duplex residences. The owners of the property sought a zoning variance requesting the ability to develop the building into an 18-unit apartment complex with 19 indoor parking spaces. The zoning board denied the request for a variance because the owners failed to establish the requirements for a variance. 1, that the denial of the variance would result in unnecessary hardship, and 2, that the variance requested was the minimum variance necessary to afford relief and the least modification possible. The owners appealed to the Court of Common Pleas. The Common Pleas Court overturned the board's decision and stated that the owners presented sufficient evidence to establish that the variance was the minimum variance necessary to afford relief. This order was also appealed, bringing us to the instant case. The Commonwealth Court found that the board did not abuse its discretion when finding that an 18-unit apartment building was not the minimum variance required to afford relief, as no evidence was presented that fewer units would not also afford relief, while requiring a lesser deviation from the current zoning regulations. The Common Pleas decision was overturned and the order of the zoning board denying the variance was reinstated. The next area of law today is tax law. In Synthes USA HQ versus the Commonwealth of Pennsylvania, the court evaluates the appropriate method for taxation when you have a corporation that operates in multiple states. In this case, Synthes is a Pennsylvania corporation but provides services to consumers outside the Commonwealth. In 2011, Synthes calculated their taxes using a cost of performance calculation. This case ultimately ended up before the court as Synthes applied for a refund, claiming they had used the incorrect calculation and should have used a benefits received calculation, which the Department of Revenue has been consistently using for many years. The cost of performance method calculates the income-producing activity as having occurred in Pennsylvania, as that is where the services were produced. The benefits received method calculates the income-producing activity as having occurred in the location where the customer received the benefit of the service. So for a consumer using the service outside the state of Pennsylvania, the income would be attributed to a different state. The Commonwealth argues that the cost of performance method is the correct method. Synthes and the Department of Revenue contend that the benefits received method is correct. Ultimately, because the controlling statute is ambiguous, the court generally defers to the expertise of the agency charged with interpretation and enforcement responsibilities. In this case, that agency is the Department of Revenue. The court does not find that the Department of Revenue interpretation of the statute is contrary to legislative intent and therefore upheld the interpretation they have used for many years, the benefits received method, and concluded that Synthes is in fact entitled to a refund. In a torts case, Podejko versus DOT, the issue addressed is the definition of in operation for purposes of the vehicle liability exception to the Tort Claims Act. The Podejkos own and operate a child care facility. During a particularly rough storm, there was significant flooding in the adjacent streets. The fire department sent out a pumper truck which pumped water from the roadways into the plaza parking lot and directed the water down the drains in the lot. The Podejkos alleged that this pumping of water caused flooding to their property, causing damage to their playground as well as 2 of their classrooms. Typically, a government agency is immune from liability. Damages can only be recovered when 1. Damages would otherwise be recoverable under common law or statute, 2. The damage was caused by the negligent act of the agency, and 3. The negligent act falls within one of 8 enumerated categories. One of the enumerated categories is the vehicle exception for acts involving the operation of any motor vehicle in the possession or control of the agency. The court evaluated the previous case law and came to the conclusion that operation does not necessarily require movement from place to place, but must also evaluate the purpose for which the vehicle is operated. In this case, the purpose of the pumper truck was not only to bring firefighters where they were needed, but its parts were also expressly designed to disperse water onto fires, or in this case, to remove the floodwaters. As a result, the court found that the vehicle exception does apply and the case is remanded to determine if the fire department was in fact negligent and whether that negligence caused the damage to the child care facility. The final area of law this week is unemployment law. In the case of Zimmerman versus Unemployment Commission Board of Review, the claimant was discharged from unemployment following a series of disciplinary incidents. The claimant was a flex driver for Walter Services. Walter Services has an attendance policy as well as a progressive discipline policy. The 2 policies build upon each other. There are 2 incidents that are pertinent for this case. These are the last 2 in a series of incidents leading up to his termination. The first incident on September 7th involved refusing to come to work on a Saturday when he didn't finish his route the previous Friday afternoon. The claimant alleged that it was not his fault that he could not complete the route on Friday afternoon, as it was not his usual route. He was covering for someone else, and that person failed to properly stock the truck to allow him to complete the route. The claimant was advised that any future incident would result in immediate termination. He then later failed to appear at a mandatory meeting on November 12th. He was immediately terminated. The claimant filed for unemployment and was denied as the board found his termination was the result of willful misconduct. The board found that the September 7th incident was irrelevant in their decision and found that the failure to appear at the mandatory meeting was sufficient to justify the denial of unemployment benefits. The Commonwealth Court found that the September 7th incident was relevant as it was necessary to determine if the employer complied with their attendance and progressive discipline policies. The court held that if the warning on September 7th was improper, claimant would not have been terminated on November 12th. The case was remanded to the Unemployment Compensation Board to evaluate the propriety of the September 7th discipline. In the Lowman unemployment case, the Supreme Court determines, in a case of first impression, if Lowman's work as an Uber driver constituted self-employment, rendering one ineligible for unemployment benefits. Self-employment is not specifically defined in the Unemployment Compensation Act. Therefore, whether or not one is self-employed must be determined through a 2-factor test, the control factor and the independence factor. To satisfy the control factor, the evidence must show that the claimant is not subject to control or direction. There is no set of hard and fast rules to determine control, and the determination must be made based on the unique circumstances of each case. Here, the court found that based on the required application to use the Uber driver app, Uber's monitoring, review, and supervision of performance, the pay structure, and the provision of tools and equipment, Lowman was not free from control or direction, and therefore the control prong was not satisfied. The independence factor looks at whether the claimant is customarily engaged in an independently established trade, occupation, profession, or business. Again, no one set of circumstances is dispositive, and each case must be addressed on its unique facts. Here, the court found that Lowman was customarily engaged in the business of driving for Uber, but based on the contractual relationship with Uber, the fact that he cannot subcontract and allow others to drive, that he has no means to contact his leads or rides outside the app provided by Uber, he was not engaged in an independently established business. Therefore, the independence prong was also not satisfied. To be considered self-employed, both prongs must be met, and as neither prong was established, the court concluded that he was not self-employed and therefore eligible for unemployment benefits. That's a wrap for today. Thanks again for joining us and listening to the Pennsylvania Case Law Update While You Drive podcast. Have a great week.
Thank you for listening to the Pennsylvania Case Law Update While You Drive podcast. Be sure to subscribe to this podcast and our YouTube channel to make sure that you are always in the know when it comes to important changes in Pennsylvania case law. We want to thank this week's sponsor, the McShane Firm. The McShane firm is a central Pennsylvania fixture when it comes to DUI and criminal defense. The attorneys and staff at the McShane firm believe in good old-fashioned central Pennsylvania values like hard work and straight talking. Give them a call if you or a loved one ever needs help.